Good morning to you all. I will ask you to take your seats. We are starting the LEAK Symposium in a few moments. Regarding people who are watching this conference online, you may choose the language you want to be translated to. And welcome you too, and hope you enjoy this day here with us. You are already seated, so we are going to start with the welcoming remarks. Bruno Monteiro, representing Validity Foundation. João Lázaro, APAV, Portuguese Support Victim, and Joaquim Pequicho from FENACERCI.
Good morning, everyone. To all of you joining us online and in person here in Lisbon. It is my pleasure to welcome all of you to the closing event of the LINK project, co-organized thanks to the wonderful work of especially APAV and FENACERCI, alongside our wonderful consortium, which you'll have the chance to listen to throughout the day. Throughout these last 2 years, we've been working tirelessly to develop more practical tools and guidance for criminal justice professionals and child protection professionals to give a better, more positive experience to children whenever they participate in the justice system. We have found that children that use alternative and augmentative communication, they still face many barriers across the European Union. Their testimony is often either discredited or excluded altogether just because of the particular device they use whenever they want to testimony. And there's also a lot of struggles and barriers to access to the support and procedural accommodations needed to be able to participate in criminal proceedings. Throughout the day, we'll have 4 different panels, which you'll be able to hear in detail about all of this. In the first panel, you'll hear more about our research findings and what we heard from professionals and children on what we should do to make the experience for children who are victims of crime, their experience, much better. In the second panel, you're also going to hear more about different technological tools, features, everything that exists that already can be used in the justice system to make the situation better. And of course, we also share our experiences whenever we consulted children and other recommendations of training tools and capacity building for professionals, so that again they're more prepared to hear and ensure the participation of children in the justice system. But of course, since our work, even though it has been almost 2 years, our work is not done. So there's going to be one last panel to define then the future directions for the project. And with this in mind, then, and before I hand over to our next speaker, as Anna has mentioned, we will count on the support of different language interpreters and sign language interpretation, especially for those joining us online. Please bear in mind to access the right interpreter that you like. And there's a particular button which you can select which language you like to listen to. And any sign language interpreter between Portuguese Sign Language, International Sign Language, which one you prefer. And then finally, I would like to say thanks once again to the really hard work of the team from APAV and from FENACERCI, really just to make sure that we have an amazing event today. If you come across any problems, please feel free to reach out. Also, if from if you're concerned about, especially for those joining us online, on sharing your name or any sort of personal data, I'd like to reassure you that any data will only be shared with the European Commission, and in any case, you also have the option to rename ourselves and not share your actual name. So, after this housekeeping, I'd like to hand over the floor to President João Lázaro from APAV.
Thank you. Obrigado. Thank you all. Thank you for being here, namely in presence, and all the people that are following us online. I will be addressing you in Portuguese, but just to say in English that it's an honor to have you all here, and it has been a pleasure to co-organize this event here. Excelentíssimas senhoras e excelentíssimos senhores aqui presentes e todos os demais que nos acompanham via online. Muito bom dia. É com elevada honra e prazer que a APAV recebe todos e todas aqui hoje, celebrando o esforço contínuo de promoção e efetivação dos direitos das vítimas de crime, suas famílias e amigos, muito em particular das vítimas particularmente vulneráveis, como é o caso das crianças com deficiência. Há 35 anos que nos investimos no contínuo esforço de estabelecer sinergias para uma melhor e efetiva coordenação de serviços a nível nacional, europeu e internacional, numa cultura de parceria e de complementaridade em favor daqueles e daquelas que se veem privados de um acesso informado e efetivo aos seus direitos e, bem assim, a serviços de apoio especializados, individualizados e sensíveis às suas particulares necessidades de apoio e proteção. Em resultado deste investimento persistente na melhoria da situação das vítimas na sociedade portuguesa que nos encontramos aqui hoje, uma vez mais, para refletir sobre como podem os esforços concertados entre comunidades, estruturas de apoio à vítima, academia e demais atores-chave ser catalisadores de uma participação efetiva das crianças com deficiência vítimas de crime nos sistemas de justiça. Portugal tem feito avanços significativos na harmonização da legislação com os instrumentos internacionais, nomeadamente com a Convenção sobre os Direitos da Criança e a Convenção sobre os Direitos das Pessoas com Deficiência. Há medidas legislativas e práticas que demonstram esse progresso. Existem equipas multidisciplinares no terreno e parcerias que procuram respostas mais integradas. Não obstante todos estes esforços legislativos, as crianças com deficiência e vítimas de crime não usufruem ainda dos direitos assim consagrados nos quadros legislativos europeus e nacionais. Diríamos que o sistema de justiça não está ainda preparado para garantir que todas e quaisquer necessidades destas crianças são efetivamente consideradas e salvaguardadas. Ainda não temos uma resposta integrada, consistente e verdadeiramente centrada na criança vítima. Dependemos demasiadamente e demasiadas vezes da sensibilidade individual de quem as recolhe, ouve e decide, o que foi, aliás, a aprendizagem mais relevante do trabalho que temos vindo a desenvolver no âmbito do projeto LINK, ao considerar a falta de presença de cultura organizacional no nosso sistema para isto. As barreiras enfrentadas pelas crianças com deficiência não são abstratas nem teóricas, são múltiplas e devastadoras. As consequências e impactos da vitimação sofrida por estas vítimas, tão particularmente vulneráveis, frequentemente relegadas ao silêncio, à repetição de ciclos de vitimação repetida e secundária. Não basta, contudo, reconhecer que falhamos, como comunidade, na garantia basilar dos direitos destas crianças. É preciso coragem política, compromisso institucional, persistência e também exigência por parte das organizações da sociedade civil com determinação para que a situação mude. É, desde logo, prioritário investir na sensibilização e capacitação dos profissionais dos sistemas de justiça e de proteção das crianças com deficiência para a importância de avaliar as necessidades individuais de apoio e proteção de cada uma destas crianças, criando os subsequentes mecanismos garantes de que estas necessidades são acauteladas em toda e qualquer fase do processo inicial, do processo penal, e não apenas na fase inicial. Urge sensibilizar para o princípio de intervenção mínima, para as necessidades e direitos, para a criação de mais e melhores políticas sociais e públicas. Para dar resposta às necessidades reais das crianças com deficiência e vítimas de crimes, é indispensável fortalecer os caminhos de colaboração entre todos os setores envolvidos. Justiça, saúde, educação, sistemas de proteção de promoção e proteção e sociedade civil devem atuar numa lógica integrada, multidisciplinar, ou como agora se ousa dizer, transdisciplinar e de complementaridade. Esta colaboração, contudo, não pode basear-se apenas em contactos informais, mas sim em protocolos claros, mecanismos de referenciação efetivos, partilha de informação e responsabilização mútua. É nosso entender que só assim conseguiremos garantir que cada criança encontra, a cada momento, os mecanismos de apoio e proteção de que necessita, sem que tal dependa do acaso ou da persistência individual do profissional que por acaso encontra. Com medidas concretas, elencamos, desde já, o reforço da formação e especialização de profissionais, a simplificação de procedimentos e maior flexibilização do sistema de justiça, a promoção de uma colaboração verdadeiramente coordenada entre sistemas ou subsetores de sistemas, a adoção efetiva de adaptações processuais e de meios de comunicação alternativa, a aposta nas tecnologias de comunicação e informação e até da inteligência artificial. Estas propostas não respondem apenas a lacunas identificadas, mas representam um compromisso com uma justiça mais acessível, inclusiva e centrada nas vítimas, em particular das crianças com deficiência. O grau de maturidade e desenvolvimento da sociedade vê-se também, e vê-se da forma como o sistema de justiça trata as suas vítimas, principalmente as mais vulneráveis. A APAV assume e reitera o compromisso claro da construção de um sistema verdadeiramente inclusivo e centrado na vítima. Reforçamos a convicção de que os técnicos de apoio à vítima desempenham um papel-chave, pelo que será nosso compromisso assegurar o seu apoio profissional, individual e sensível às crianças com deficiência, vítimas de crime e de violência em todas as fases de processo. Caros e caras colegas e amigos aqui presentes, termino com a sublinhada certeza de que o dia de hoje será repleto de momentos de aprendizagem, de partilha de boas práticas, de diálogo, de reflexão e de sedimentação de parcerias e networking. E mais do que isso, de um debate alargado e necessário para as crianças com deficiência vítimas de crime. As mudanças necessárias implicam que o paradigma atual se transforme na adoção de uma verdadeira abordagem centrada na vítima com deficiência, vítima de crime e de violência. O que significa, acima de tudo, ouvi-las, envolvê-las, adaptar os serviços às suas necessidades individuais e não o contrário. Muito obrigado e uma ótima conferência para todos nós e para todos e todas. Muito obrigado.
Good morning, welcome to Lisbon. I will do the same as João Lázaro. I will address to you in Portuguese. E, por isso, sejam muito bem-vindos a Lisboa. Destacar 2 ou 3 aspectos nesta minha intervenção, dizendo desde logo que estou confortável porque eu faço das palavras do João Lázaro as palavras da Fernanda Sérgio do ponto de vista do compromisso, das preocupações e dos desafios que o João Lázaro, em representação da APAV, acabou de sinalizar. Eu daria só mais 2 notas de contextualização de uma forma mais ampla, até porque durante o período da tarde no painel teremos a oportunidade de incidir mais sobre a razão das nossas intervenções aqui neste seminário. Acima de tudo dizer que é uma honra fazer parte deste consórcio muito alargado de entidades que estão muito comprometidas, não só no contexto europeu, mas, acima de tudo, uma honra do ponto de vista da nossa relação no contexto nacional, onde temos encontrado momentos muito interessantes de trabalho e de aprendizagem e de construção do conhecimento que temos vindo a fazer e, acima de tudo, de destacar ou sinalizar a dimensão humana e a condição humana que temos encontrado em cada uma das organizações com quem nos temos envolvido. Obviamente dirijo-me à APAV, tem sido um processo de aprendizagem e não é muito fácil, às vezes no contexto nacional com tantos compromissos trabalharmos em conjunto, mas a missão, os valores, os princípios que representamos acho que tem sido um momento feliz e um momento de continuação do nosso trabalho, mas eu colocaria também neste ecossistema de entidades com quem temos vindo a trabalhar, a Ordem dos Advogados, o Conselho, a Procuradoria de Justiça, todo um conjunto de parceiros nacionais que têm sido extraordinários no caminho que temos vindo a fazer, quer no projeto Link, quer nos outros projetos onde estamos integrados, o Enable, o Disconnect, temos feito um longo caminho com a Validity. Porquê é que eu sinalizo isto? Porque A determinada altura, a FENACERSI, que hoje faz 40 anos, fez no sábado 40 anos da sua existência, a FENACERSI considerou que devia investir todo o seu esforço, toda a sua capacidade instalada, todo o seu pensamento crítico em algumas áreas estratégicas que, acima de tudo, geram impacto nas pessoas que apoiamos e nas pessoas que servimos. Porque muitas das vezes as organizações gerem oportunidades de contexto, gerem oportunidades que vêm de financiamento, dispersam-se em muitas áreas e não têm estrategicamente um foco que lhes permita investir e gerar impactos nas pessoas e nas famílias. O que nós fizemos foi concentrarmos todo o nosso esforço em 3, 4 dimensões importantes que eu partilho convosco muito rapidamente. A questão da inclusão comunitária e os desafios que hoje se colocam às organizações do ponto de vista da inclusão comunitária, das suas consciências, das suas famílias. A inclusão comunitária, peço desculpa, agora tive um pequeno lapso de memória. A acessibilidade cognitiva, no sentido de cada vez mais investirmos em ferramentas, em caminhos que permitam trabalhar mais a leitura fácil e todo esse investimento que é necessário fazer. A inclusão comunitária, a questão do grande desafio que se coloca hoje às organizações tem a ver com o envelhecimento das pessoas que apoiamos, e nesse contexto o envelhecimento das pessoas que apoiamos, o envelhecimento das próprias famílias, em que hoje existe grandes desafios, não só da sociedade no geral, mas fundamentalmente na realidade das pessoas com deficiência e naquilo que é hoje a resposta das organizações e a necessidade de transformar também o modelo e os serviços que são prestados em função do envelhecimento, e depois a acessibilidade à justiça como um grande tópico transversal a tudo o que estamos a fazer, acima de tudo, porque entendemos que é uma garantia dos direitos, e a acessibilidade à justiça é um primeiro garante desses mesmos direitos. Bom, isto é só para dar, assim, genericamente, as áreas onde estamos estrategicamente a incidir, não focando a minha intervenção naquilo que será hoje a jornada de trabalho, que vai ser muito intensa e que vai trazer um conjunto de marcos e desafios para o presente e para o futuro, e naturalmente estamos comprometidos com esses mesmos desafios, mas assumidamente gostaria de sublinhar aquilo que disse inicialmente. O facto de estarmos a trabalhar num consórcio tão alargado, com um conjunto de parceiros que, acima de tudo, representam uma grande dimensão humana e um grande compromisso com os direitos das pessoas, é para nós um motivo de orgulho. E, naturalmente, nos 40 anos da FENACERSI, tudo aquilo que assistimos no nosso ecossistema também organizacional, de transformação organizacional, transformação das culturas e das práticas das organizações, dá-nos um redobrado, diria, sentido de esperança e de vontade de continuarmos a trabalhar, e, obviamente, agradecendo à Validity o facto de nos considerar nesta parceria, e à PAV por ser um parceiro extraordinário, não só pelo trabalho que fazem, mas, acima de tudo, por aquilo que vamos nos conhecendo mutuamente. Muito obrigado.
Thank you, everyone. And with these very kind words, welcome, I hand over to Anna, and we can give a start to the first panel.
Thank you so much. So we are going on with this conference, and for the first panel, I will ask to take the stand Bruno, who is already there, Ana Bat, Leonor Bernardo Costa from APAV, Lúcia Canha from FENACERSI, Ugni Grigat, and Aleksandra Ivanković, already there. So the floor is yours.
So, Good morning, everyone. And thank you very much for giving me this opportunity to participate and to contribute to this amazing panel today. I have some very, very good participants here, and I hope that Anna joined us also online. Let's start. Just as an introduction, I'm Aleksandra Ivanković. I'm Deputy Director of Victim Support Europe. Victim Support Europe is the European umbrella of victims support organizations. We're advocating for rights and support for all victims of all crimes, regardless of who the victim is and what crime they suffered. And we have been very proud to have been partners in this consortium that has been led by Validity. So I will just briefly ask the panel participants to introduce themselves, although I guess we all know each other, but it's always good to be reminded of who is sitting with us and what are the amazing organizations they work with. So maybe Bruno?
Of course. Hi once again. My name is Bruno Monteiro. I'm the Programs Director from Validity Foundation. Validity Foundation is an international NGO that promotes the rights of persons with disabilities globally. And it's really a pleasure to be here and enjoying this amazing consortium spanning over 11 countries, I believe. And here on my side, I have Lucia.
Lucia, yes, it's me. My name is Lucia. I'm technician of education and special rehabilitation. I research in disability area, and on the LINK project, I'm a researcher from LINK project. So I'm glad I'm here. Good morning.
If Anna is online, I don't have a screen in front of me, so Anna, if you can maybe introduce yourself and bits.
Yeah, can you hear me well?
Yes.
Great. Yeah, good morning, everyone. So I'm Anna from PITS, from Slovenia. That's a legal center for the protection of human rights and the environment. We're covering a range of topics like asylum and migration, people with disabilities, housing rights, and so. And one of our focus areas and priorities, also actually like the Ministry of Justice, is now the focus on children and their position in criminal and civil proceedings in Slovenia. So I'm happy to join this discussion today.
Thank you, Anna. Anna, very happy to have you here. Leonor?
Hi, good morning, everyone. Thank you for being here as well. I'm a project manager at APAV. I'm a sociologist, and I'm working in LINK project as well.
Thank you. Hello, everyone. My name is Ugnė Grigaitytė. I come from Lithuania. I represent a Lithuanian NGO called Mental Health Perspectives. I hold a PhD in global public health, and I've been working in the field of mental health, disability, and human rights for quite some years. Very nice to be here. Thank you.
Thank you. So what this panel has been assigned to discuss and present, and what we will be doing in the next hour or so, is looking into the famous work package 2, research. So one of the things that we tried to do through this project is to do an informed overview of what are the obstacles for children with intellectual and psychosocial disabilities who are victims of crimes and who participate in criminal proceedings. And we know from previous research that persons with disabilities are much more likely to fall victims of crime. We also know, well, let's start first with the biggest data, and that is that the European Union estimates that 15% of EU nationals fall victim of some type of serious crime every year. And that means that every 7th person in this room is, statistically speaking, likely to become victim of a crime that's more serious than just, like, you know, pickpocketing. And then amongst these 15%, the persons with disabilities in general are much more likely to become victims. And then persons with intellectual and psychosocial disabilities are still much more likely to become victims within this group. And then but we really don't have the data. We don't know precisely. It's all based on on assumptions, it's all based on projections, because obviously we can only be sure about the official crime statistics about crimes that are reported, and the non-reported crime is this gray figure that's always kind of looming somewhere. So it's actually very difficult to know. And then it's even more difficult to know what is the victimization of children with intellectual and psychosocial disabilities, because those numbers are probably the darkest. We know that unfortunately many of these children are placed in institutions. I know that Validity is arguing, and with quite a good kind of stance, that institutionalization itself should be a criminal act and not just, you know, like something that people do with their children. It's childcare. So we also know that persons with disabilities are obviously much less able to reach out to institutions, have much less opportunity to actually report crimes compared with general population, and then that's much more true for children with disabilities. We know that there are issues of accessibility for example, children's helplines. There is issues with just getting the information across, making children with disabilities aware of their rights, making them aware of the possibilities to file a complaint, to report a crime, or even to understand that they have been victims of a crime. I always remember I was talking to a person, a senior police officer, now retired, who was one of the people who set up the hate crime unit in London Metropolitan Police. And they were working on a case that actually concerned a child with intellectual disabilities who was victim of a hate crime. And the crime was that their friends were basically interacting with this child by spitting on him. And the child thought that was normal. For him, that was just how his friends were interacting with him. And he didn't see anything unusual in the fact that his so-called friends were actually insulting him and doing this horrible hate crime, because this behavior was so normalized in his life that he didn't see anything wrong about it. So these are the sort of things that we need to discuss. Also, for example, we have some people from Sweden here. We know that in Sweden, you cannot commit hate crime against a person with disabilities because the disability community chose not to be protected with this legislation. And then it's the question of like how participatory was this decision when it was being made. So I'm opening many cans of worms in this introduction, but I thought that was important to kind of to remind ourselves about what are the difficulties, not just methodological kind of difficulties around how do you phrase questions and conduct interviews, etc., but also what is the reality in which we were expected to do this work. And then, you know, like the kind of barriers and complexities showed up as we were working on trying to think about how to understand what is the reality for children with disabilities in actual courtrooms, because obviously, given all these reasons that I've raised, there are many issues around how many crimes are actually reported. We see that for victims, all victims of all crimes, and then the more complex it is, the less likely it is that an investigation will actually happen and that it will come to criminal proceedings, because unfortunately prosecutors have to pick low-hanging fruits. They have to make the infamous cost-benefit analysis, in the sense of, I have, you know, like very bluntly speaking, I have this adult articulate person who's very well able to sit down and explain what happened to them and can give a convincing testimony to a court. And then I have this non-verbal child with disabilities, and someone is telling me that someone did something terrible to that child, and that child cannot be brought to testify because they cannot actually make a statement. And then, you know, how do you actually, as a prosecutor, I mean, you know, they also have their objectives and they need to kind of deliver numbers, unfortunately, etc. So just from a very practical and very sort of unfortunately objective in the world that we live in, point of view, it's also difficult to get that work done and to get those kinds of investigations, to collect evidence, to present cases to courts, especially in a reality in which we know that rights of victims are very rarely implemented, as opposed to the rights of the accused that have a very strong, structured implementation paths and case law and very kind of consequential provisions where, like, you know, if you don't respect the rights of the accused, your case will collapse and your state might be forced to pay compensation to the accused, regardless of, you know, how obvious it may be that the crime actually happened and that this person committed it. But if you haven't, you know, like, crossed all the T's and dotted all the I's, your arrest warrant will be quashed, and then your entire evidence will be declared inadmissible and you no longer have the case. Whereas if you simply ignore the victims, you disrespect them and you expose them to secondary victimization and you allow, like, you prosecute them. We just saw a recent case law from the European Court. You prosecute them for false reporting because they were bullied into withdrawing criminal complaint, then you still have no consequence or very little consequence. So unfortunately, victims in criminal proceedings are disempowered, and then that's for all victims, adult persons who are very eloquent and articulate and empowered, etc., have terrible time in criminal proceedings, and then just kind of like thinking about a child, and then thinking about a child with a disability, and then a child with an intellectual or psychosocial disability. We understand that, like, the barriers are kind of getting more and more numerous, and it becomes more and more difficult to even have such a victim see their day in court. And then we are exposed with obstacles around lack of accessibility, absence of reasonable accommodations, etc. So it's really a very pessimistic reality for children with disabilities who have to face criminal proceedings. And so this is why this project is so amazing as well, because it's addressing an issue that very few people go to and very few people even explore, because it's not in our faces. It's not something that you will see, like, on your, like, mainstream media or whatever, like, you know, being put into your face. It's not about a topic that that everyone wants to talk about, that's out there, but it's still, like, understanding the complexities and also, like, the pain we cause to the most vulnerable victims. I think it was really, really important to explore. So having said that, I think I've kind of depressed us enough for a day. But also I think that was a background that had to be tackled through research. We were trying, of course, to like, methodologically speaking, have as many research techniques as possible. But what was really important in this research was to hear experiences from these children, because, and I also, like, I used to work in invalidity, which was called MDAC back then. And I say that, like, my job now is only the second best job, because my job in validity was the best job. But don't worry, Stephen, you're safe. But I know a thing or two about the issues of victims with disabilities and with intellectual and psychosocial disabilities. So that's why I personally found it very, very valuable to be in this project. And that's why I personally found it very, very important also to try to insist through our methodological tools to make sure that we hear the voices of those victims. Because it's so easy to not do, and it's so easy to find an excuse and to find an objective reason to say, no, we don't want to kind of talk to them because they're already traumatized, and we don't want to make them uncomfortable, etc., etc. And there are obviously many ethical issues, there are obviously many data protection issues, etc. And we really tried to work, well, the partnership, because they did the work of research, they really tried to do their best to make sure that this was very ethical but also very inclusive. And so at that, I will thank my fellow panelists for joining. And before we kind of dive into the details of the research, we actually discussed about painting a bit of a broader picture around the reality of victims in criminal proceedings and of understanding how we can make criminal proceedings less traumatic to begin with for victims in general, and then victims with disabilities in particular, then children with disabilities in particular. So I would open with my dear colleague from APAV, Leonor, who I would really like to ask. So obviously there is the Victims' Rights Directive should be the guiding instrument when we talk about rights of victims of crime in the EU. And it's an instrument that's been in place since 2012. And it's an instrument that will be hopefully upgraded soon. The EU is discussing very, very intensely at this moment about adopting a revised Victims' Rights Directive. But there is this one provision in the Victims' Rights Directive that's called Article 22, which talks about individual needs assessment. That is a requirement to be conducted for all victims of all crimes in a timely manner. So I will ask Leonor about what are the requirements of the individual needs assessment, and how does that work or doesn't work in practice for victims of crime in general. Thank you, Leonor.
Thank you, Alex. Well, first of all, I think I'm going to speak in Portuguese, so if you want this, because I believe my colleagues from the translation team will do a better job than me, and I really want to explain myself the best I can. So, thank you for the question. A diretiva veio estabelecer então normas mínimas de proteção e apoio para vítimas de crime. Este é o objetivo, o grande objetivo da diretiva, e é por isto que ela existe. A diretiva não é suposto ser um instrumento jurídico, uma coisa muito burocrática, é de facto um marco ético, é de facto algo que existe para termos a certeza que todas as vítimas, independentemente da nacionalidade, do sexo, onde o crime tenha ocorrido, têm direito a um apoio especializado, têm direito à informação e têm direito à proteção por terem passado por aquela situação. E quando eu digo todas as vítimas, naturalmente e obviamente, eu estou-me a referir também a crianças com deficiências intelectuais e psicossociais. Mas, por alguma razão, estas crianças continuam constantemente a estar aquém e a estar atrás destes direitos que lhes são reconhecidas. E a diretiva, e já vou chegar ao artigo 22, tem aqui 3 marcos que eu acho muito importantes. O primeiro é o apoio especializado. Qualquer vítima de qualquer crime tem direito a apoio especializado, e isto implica um técnico que tenha formação nesta área. E se falamos com crianças com deficiência, naturalmente, e por fator da interseccionalidade, temos aqui vários fatores e tem que ter alguma especialização no tipo de deficiência que estamos a falar. A vítima também tem direito à informação. E quando falamos de crianças com deficiência, se queremos que esta informação chegue à vítima, temos de nos adaptar a linguagem, adaptar como falamos com a vítima, adaptar o tempo desta comunicação, e só com estas adaptações é que a vítima fica plena com os seus direitos, ou seja, só com adaptações é que a vítima tem acesso à informação, porque se não nos adaptarmos, se comunicarmos com a vítima, e neste caso uma criança e com deficiência, da mesma forma que falamos com qualquer outra pessoa ou uma criança, a vítima não vai ter este direito consigo. E, finalmente, chegamos ao artigo 22, a avaliação individual das vítimas. E o que é que este artigo diz? Diz que, supostamente, todas as vítimas devem beneficiar de uma avaliação individual para percebermos que medidas de proteção e de apoio é que a vítima precisa para acompanhá-la durante todo o processo penal. Temos que perceber quais é que são estas necessidades e como é que podemos aplicá-las. Novamente, não é um sistema burocrático, é uma coisa prática para percebermos como é que podemos ajudar a vítima e não revitimizá-la novamente durante todo o processo. Isto dá acesso à justiça de uma maneira mais igualitária, dá segurança, dá compreensão e, acima de tudo, dá dignidade àquela pessoa. Quando estamos a aplicar esta avaliação, nós devemos ter atenção em algumas coisas. A primeira é, se ao longo deste processo, se a vítima corre risco de ser revitimizada, e se sim, como é que podemos não correr esse risco, não é? Nesta avaliação temos de ter esta percepção. Que obstáculos é que podem estar implícitos à participação da vítima durante o sistema. E aqui, naturalmente, quando falamos com vítimas com deficiência, se calhar estamos a falar de linguagem, não é? A vítima consegue falar, a vítima consegue compreender, a vítima consegue dar a sua visão. E aqui o obstáculo pode ser simplesmente uma luz. O obstáculo pode ser simplesmente um som ensurdecedor que está a causar uma complicação imensa para aquela pessoa estar concentrada e conseguir falar e conseguir contar a sua história. Portanto, estes obstáculos são muito importantes. E depois, como é que podemos garantir que a vítima tem voz ao longo de todo o processo? Então, com uma criança com deficiência, isto ainda traz um bocadinho mais de preocupação, porque nós temos que perceber o que é que aquela vítima percebe. Aquela vítima percebe que foi vítima de crime? Conseguimos comunicar com ela? Temos que nos ajustar? Não temos? Ou seja, todas essas preocupações, todos estes ajustes têm de ser feitos com qualquer vítima, com uma criança ainda mais e com uma criança com deficiência ainda mais. E diria eu que uma das primeiros passos, e que se calhar a diretiva aqui falha, é como é que podemos comunicar com a criança, não é? Quais é que são os meios de comunicação que a criança utiliza? Porque muitas vezes o que nós vemos e vimos através do projeto Link é que se não for uma conversa e uma comunicação normal, convencional, como nós estamos habituados, a criança fica por ali, entramos logo mal no sistema, porque muitas crianças que se calhar precisam de outras formas de comunicação, entre elas comunicação aumentativa e alternativa, e que na avaliação das vítimas não está contemplado. Portanto, eu diria que uma das necessidades desta diretiva que temos que nos debruçar para o futuro é que esta avaliação esteja adaptada a crianças com deficiência. Tem de ser feita por profissionais especializados que sabem o que estão a fazer, porque muitas vezes, e mais uma vez foi o que nós vimos nas entrevistas, estes profissionais estão a revitimizar a criança sem saber que estão a fazê-lo, porque não têm informação. O que nós acreditamos que pode ser um bom ático, pode ser podemos estar a ser profissionais, pode ser exatamente o contrário. Portanto, formação, a ferramenta tem que estar adaptada, temos de ter tempo, temos de ter metodologias, temos de ter instrumentos. Não podemos, se calhar, aplicar esta diretiva e esta avaliação de uma maneira convencional, com um papel e uma caneta, como às vezes fazemos. Temos de ter jogos, temos de ter outras maneiras de comunicar, temos de ter uma sala adaptada. Muitas vezes é com espelhos, por exemplo. Portanto, temos que pensar o que é que aquela criança precisa. E, quando identificamos estas necessidades, temos que conseguir pô-las ao longo do processo. Não é só identificá-las e depois não conseguimos, lá está, ir além. Portanto, o sistema também tem de estar preparado e tem de estar aberto a receber estas sugestões. E estas sugestões podem ser, se calhar, o procedimento, quando a criança está aqui no processo, se calhar é bom a criança estar num ambiente que conhece e não ir fora, ir a tribunal, ver um juiz com uma vestimenta estranha, ter um juiz muito acima dele. Ou seja, todas estas recomendações têm de ser bem aceitas pelo sistema e que não estão a ser ainda. Esta necessidade, uma das sugestões que nós damos é que esta avaliação tem que ser feita logo no primeiro contacto, porque se for feita logo de início, nós conseguimos diminuir este risco de vitimação. Tem de envolver equipas multidisciplinares, porque só todos juntos, com muito conhecimento, é que conseguimos fazer, e tem de ser revisto ao longo do processo. Ou seja, tem de resultar de medidas que consigam ser adaptadas e ajustadas ao longo de todo o processo. A diretiva e a avaliação e concretamente o artigo 22 é algo muito bom, ou seja, isto dá valor à vítima, humaniza a vítima, mas temos de ter rigor técnico, temos que perceber que nem todos somos iguais e que precisamos de adaptação. A igualdade também significa equidade, portanto temos que perceber o que é que aquela pessoa precisa ao certo. Portanto, eu acho que estas são assim as visões principais que eu tenho para dar.
Thank you so much, Leonor, for this very insightful look into the Article 22. I would just add, as a lawyer, that what is really important in Article 22, it's a legal provision. It's an obligation of all the member states to actually apply it. They can't not apply it, but they still do not. And I think that that's a huge problem, and we need to think about, especially like with colleagues from Validity, how we can use this legal tool to actually make sure that member states do implement this provision, because what the provision, it's actually quite explicit in how this should be done, and it has to be done in a timely manner, and it has to be updated throughout the proceedings as the circumstances of the victim change. And what Leonor has said, and I think we can't emphasize that enough, is that the assessment needs to be done for a certain number of risks that are external, and that I don't think that's a problem when there's a threat from the offender, when there's a threat from, I don't know, the other stakeholders. But what the authorities are systematically failing to address is this risk of secondary victimization, which is victimization that is committed by the authorities with their insensitive and hurtful approach. And we have these testimonies, and I'm pretty sure that colleagues from APAV hear this on a daily basis, where the victim says the police interview was worse than the crime itself. Having to talk to the police about how I was raped was actually worse than being raped. And so I think that there's a lot of work to do there, and this is what this LINK project was about, in terms of trying to find, as you say, Leonor, technical tools to respond to the challenge of responding to the needs of victims. So I will now go to Anna, who's joining us online, to tell us maybe about how in practice it is challenging to address this, and especially, I would say, in a country like Slovenia, where victims' rights are still, like services are not as developed as maybe in Portugal. So Anna, the floor is yours, if you can tell us what are the challenges with the implementation of Article 22 in practice. Is Anna still with us?
Yeah, I now managed to unmute. Thank you. Yeah, thank you for the question and the discussion before. So I think when it comes to implementation, it's first important to look at how it is implemented for victims in general, then for child victims, and then child victims with intellectual and psychosocial disabilities. Because there are some specificities. And in our research, we started first from the broad point of view, how is it implemented on a general level for victims? And we already see gaps in that regard, that on a general level, the Victims' Rights Directive is not implemented well. So then even more so, there are obstacles when it comes to child victims or victims with disabilities, because they need even more adaptations and protection. I think I'll just pose a lot of questions, actually, because then we have another issue of how to ensure that it's implemented equally in all geographies. For example, Slovenia is very centralized, so victim support is available, but only in Ljubljana. We have the special victim support office, and it's only available to victims in the district court of Ljubljana, not, for example, in smaller villages or other parts of Slovenia. We also had issues actually defining what does it mean timely? What does it mean at the first moment with officials? Because we interpreted it as, when the police comes into contact with the victim, the first assessment, like preliminary assessment, should be done. But actually, in reality, we saw that police only do the assessment later on when they already gather information. So it could be a few weeks, a few months, depends on the process. So these are just some of the points to illustrate that I think on paper the Victims' Rights Directive was transposed to the Slovenian law, for example, but in practice we can see a lot of gaps. So it's also quite unclear what does it mean individual assessment. First, at the beginning of the research, we're like, okay, it means that the police do the first assessment, but then we recognize that the Centers for Social Work, for example, they also do their own assessment. And we were trying to understand if they interlink one to another, if one is informed with the other, if social workers conduct the assessment together with the police. So these were all the questions that are still open, I think, and the directive leaves quite a lot of discretion to the national authorities to decide how this is going to be implemented. Maybe another thing I wanted to stress is that it's, at least from our point of view, we still don't know what are the possibilities for adaptations. Of course, we can suggest to the court that they use the screen or separate rooms to interview, for example, the child and the offender. But I feel like there's more procedural accommodations that we could make use of, but we are unaware, or the victim is unaware what they could ask for when they're in a proceeding. So yeah, maybe just some points to illustrate that. Of course, on paper, it's quite good. We implemented it in 2000. We transposed it in 2019, but we see that 6 years later, we still need quite a lot of discussions between stakeholders to learn how to improve this individual assessment and actually what does it even mean. Maybe for the beginning, that's it.
Thank you, Anna. And I think that, I mean, what you found in your research in Slovenia is actually quite common across the EU. So we see very few member states where individual assessment is conducted for every victim across their territory. And then, like, even in the countries that are high performing in terms of police assessment, where the police is trained and have, like, okay, let's say, a certain amount of resources, because I don't think they ever have sufficient resources to deal with the needs of victims. When the case is transferred to the prosecution, then there is rarely this kind of revision of the needs assessment and whether needs have changed. And then when you get to the court, then it's even more rare. And then eventually we end up basically causing secondary victimization. Also, like if you have 2 or 3 institutions doing the same thing at the same time and don't talk to each other and then talk to the victim with the same questions for the same purpose, but just for their different respective institutions, that also should be avoided. So thank you for that. And now I'm going to go to Ugne to just ask her if she can identify some of the obstacles, particularly because that's kind of how Anna also structured it, like you have obstacles for victims in general, and then victims with disabilities in particular, and then children with disabilities who are victims of crimes. So I would just ask you, Ugne, maybe to identify some of the issues that might be pertinent for victims with disabilities facing criminal proceedings.
Yeah, thank you. I think it's a very important point to realize that, once again, that what we're talking about as being, an obligation under the law, European Union level as well as national level, when it comes to implementation, it's very different to what it should be. And the fact is that in many countries, including Lithuania, where I come from, there is a serious lack of individual needs assessments. Therefore, tailored procedural accommodations are almost absent, or there's a lack of them. And when it comes to victims of crime who are children in general, but especially who are children with disabilities, I think it's extremely important to identify these needs, which could be to do with communication styles of children or communication aid needs, emotional needs, physiological routines, even like rest and eating schedules, or some sort of medication needs for children with some types of disabilities. And if these needs are not addressed or recognized even, then of course these children cannot participate effectively or at all in any of these proceedings. And for children with disabilities, of course, it could be a lot to do with communication, for example, because to be able to participate, of course, they might need some communication aids, like easy-to-read materials, or even just simplified language, augmentative and alternative communication methods, which are rarely used from what we've seen in our research. So the problem also is that to identify or recognize these needs, professionals who should be implementing these assessments, of course, need some specialized knowledge, how to communicate and work with children in general. And then, of course, when it comes to children with disabilities, we have many different disabilities and mental health conditions, psychosocial disabilities, intellectual disabilities. All these groups of children have specialized, specific knowledge and skills that professionals should have, but often we see don't have in order to implement this and to make sure that the justice process doesn't fail these children and doesn't fail to adapt to their needs to be able to participate and to ensure the right to be heard, ensure the right to access justice, and so on. And another, so yes, we have like a legal level, which is problematic. We then have, of course, the knowledge and skills level of professionals to do these assessments, which is also problematic, and there are a lot of gaps. But also then we have even broader picture of professionals in different institutions and different sectors sharing this information. Even if the individual needs are assessed and identified and addressed by whoever did the assessment, we see that often this information doesn't travel anywhere further, and then at the next level the child might end up even experiencing secondary victimization because of that. So it's a very multifaceted problem, and in practice we see there's a lot of gaps and barriers that really need to be addressed to ensure that children and children with disabilities can in fact participate at all in these proceedings.
Thank you, Ugne. Indeed, you're raising some very important points, and I think that data sharing and what we see, and I'm pretty sure that everyone across the room can confirm that, there is a seeming over-interpretation of GDPR. So all of a sudden GDPR is now an obstacle to like share information when we know that not sharing will actually hurt the person that we hold the information about. So many issues to deal with, but I couldn't think of a better group to discuss this and try to find solution than this group. So thank you, Ugne, for addressing the issues, especially of children in criminal proceedings, children victims. So Lucia, obviously, as FENACERCI, specializing in supporting persons with intellectual disabilities and their families, and I know that your organization has a lot of experience working with children. What can you tell us about the particular obstacles of children with intellectual disabilities who are victims, and how do we fail to assess their needs properly and address them in line with Article 22, but in general just in line with responding to their needs?
Mm-hmm. I'm speaking in Portuguese as well, so... Mm-hmm. I'm so sorry.
I'm so embarrassed. I'm the only non-Portuguese.
You can try, but I can tell you that it's very difficult. Eu acho que os desafios que foram postos pelas minhas colegas são muito comuns, são comuns também às dificuldades intelectuais, mas obviamente existem aqui desafios adicionais. A dificuldade intelectual, e sabemos números, não sabemos números exatos, como a Aleksandra já falou, mas temos alguns estudos e temos tendências, e sabemos que as pessoas, as crianças e os jovens com deficiência intelectual estão mais expostos à violência, queixam-se menos. Apesar de estarem mais expostos à violência, queixam-se menos porque acham mais que não vale a pena queixarem-se. Isto é um assunto muito grave. Também acontece com as deficiências sensoriais e físicas, mas mais com a deficiência intelectual. E quando se queixam, o seu depoimento é mais provável que não seja visto como fidedigno. E isso também é outro problema. Portanto, existe este enquadramento de estar, destas crianças e jovens com dificuldades intelectuais estarem envolvidas em mais expostas ao risco, e este risco, e face a uma situação de vitimização, ela é menos denunciada. Depois existe o problema que já foi falado anteriormente da participação. E a participação na deficiência intelectual existe. Quando existe uma situação de violência, há sempre uma distância entre a situação, a percepção da vítima em relação àquela situação e a percepção de quem ouve a vítima em relação ao que a vítima diz. Portanto, e esta distância é muito maior na dificuldade intelectuais. Primeiro, porque muitas vezes, e como a Aleksandra já disse, a própria pessoa não sabe dos seus direitos e não sabe que está sujeita a uma situação de vitimização. Mas quando sabe, porque durante o seu desenvolvimento não lhe foi perguntado, nem está habituada a responder a perguntas como é que te sentes, o que é que tu pensas acerca disto, também não está habituada a expressar-se. Portanto, normalmente a criança e o jovem com deficiência intelectual, não estou a dizer que é transversal, mas existe esta tendência, a tendência está estudada, e isto é uma questão de autodeterminação. As crianças não estão habituadas, nem têm literacia emocional para expressarem o que sentem, as suas dores, e para expressar as suas opiniões e para se defenderem elas mesmas, muito menos que as outras crianças. E, portanto, isto é um problema porque há como que uma invisibilidade destas crianças e destes jovens que pode ser internalizada. Portanto, eles podem internalizar esta invisibilidade e isto faz com que, se calhar, eles pensem não vale a pena eu expressar a minha dor, o que eu estou a sentir, as minhas experiências, nem defender os meus direitos. E, se calhar, por isso, os estudos que dizem que as pessoas com deficiência intelectual reportam menos. Depois há as questões que já foram faladas da comunicação. Obviamente, a criança e o jovem com deficiência precisam mais que qualquer outra deficiência da linguagem simplificada e, muitas vezes, a deficiência intelectual vem junto com outras deficiências físicas, de expressão e, portanto, também as tecnologias assistivas, as tecnologias de comunicação aumentativa e alternativa, mas também penso que aqui é muito importante esta pessoa mediadora da comunicação, que não será alguém que vá falar por esta pessoa, só em casos extremos, mas ser alguém que dá segurança psicológica àquela criança e àquele jovem para falar por si mesmo. E mais que segurança, que seja uma pessoa que empodera a criança, dá-lhe empowerment psicológico para que ela seja capaz e perceba e tenha confiança que é capaz de se expressar. E esta pessoa mediadora também acho que é importante para criar um ambiente que a criança sente como seguro, com o tempo, como a Leonor diz, com o tempo que necessita para se expressar. Portanto, eu penso que estes são os maiores desafios que existem aqui, esta questão da alta determinação que não está trabalhada e que, portanto, que precisam maior, no fundo, precisam maior suporte para aquela criança ser defendida e que este processo de passagem pelas portas da justiça seja um processo que a criança sinta como justo, porque senão isto resulta em trauma. Se não resultar, se for, eu penso que, e pelo que ouvimos, e ouvimos já, felizmente, crianças e jovens vitimizadas durante este projeto, e percebemos que este processo pode acabar mal, porque os direitos não foram assegurados, mas também pode acabar bem. A criança pode ganhar resiliência neste processo, se for bem acompanhada, ou pode ficar traumatizada e, portanto, é um processo que não foi benéfico para ela. Portanto, estes são os perigos.
Thank you so much, Lucia. And I think you've really raised a very important issue, which is about fairness. And I think that we kind of lose that from the side about justice and fairness of being involved in criminal proceedings. And they call it criminal justice, but then we feel that it's rarely justice for the victim. So thank you for that. That was very insightful. So last but not least in this first round of questions, Bruno, because Bruno was obviously working in validity on overall research and looking and from the kind of bird's eye perspective. So can you maybe, having given this quite blunt and bleak picture, tell us about, is there light at the end of the tunnel? Can you give us maybe some good examples, good practices that could have been identified and that could serve as inspiration to try to resolve some of these issues?
Thank you, Aleksandra.
I'll speak in Portuguese as well, right?
No, not this time.
Thank you. Thank you for your solidarity.
I'll have a slide for as a support. So, as all panelists shared, we tend to find a lot of bad examples, but there actually are a lot of good examples and things that we can do already to make the experience for child victims better whenever they participate in the justice system. And as Lucia was sharing with us, it's important to see the process itself as rights of the victim, that they have a right to have a say in the process and decide what exactly and to what extent they would like to participate in the process. And as we mentioned already, so in this project we're covering 8 different EU countries. In Link we started out with 6. You got a list in the slide, and thanks to co-funding from FIRA, we're also adding to the experience everything that we're learning from Hungary and France as well. I'm going to share a preview but of course, the final report is planned to be published sometime in June or July 2025 later on. Next slide, please. I'm not going to repeat a lot of this because the panelists already mentioned. What I would like to flag in particular is that thank you. What I would like to flag in particular is how important it is for there to be an individual needs assessment, as the panelists already mentioned. The Victims' Rights Directive flags and already mentions the need for adopting different protection measures for children. And Leonor already mentioned, for example, the blue rooms, and also the need to avoid repeated questioning and interviews. And also, as Aleksandra mentioned, is even when the individual needs assessment is performed at the beginning, it needs to be continuously updated and make sure these measures exist across the proceedings. Now, what we found in the multiple countries is, well, there's a lot of things happen. So in some countries there is some sort of individual needs assessment, but it's not consistently done by everyone. It depends a lot on the goodwill of whoever is performing at the time. Or sometimes individual needs assessments are just not performed at all, unfortunately. And even then, when an assessment is performed, it tends to be focused more on protection needs. It tends to be sometimes forgotten the measures that we allow for adoption of procedural accommodations. And by procedural accommodations, I mean any sort of adjustment in the justice system that will allow the child to be able to communicate, express their feelings, their views, be able to have a say in the process. And for this to happen in practice, it actually requires the cooperation of a lot of people from involved in the child protection systems, in criminal justice, and even outside of it, sometimes in schools or other stakeholders from the social field. So there's a lot of people involved, a lot of confusion can happen, and all of this flags how important it is. And as João mentioned, and Leonor, but all panelists need for more standardization, more protocols that would define very clearly how it should be done by who and when. And it also flagged the need for more data sharing and information sharing, because different people will hold different information, different parts of the puzzle of what's happening to the child to really try to understand the overall situation. And unfortunately, especially as Aleksandra has already mentioned, there's a lot of fear, especially on account of the data protection regulation, of what information can actually be shared, by whom, to what extent, which of course there's a lot of good reasons to be cautious about it, but we don't believe it insurmountable, and in the end, if it's necessary to provide the necessary support and protection for the child, that shouldn't be an obstacle. And unfortunately, all of these cooperation barriers and also lack of understanding of disability and what children can do has led to, well, we found that there's really very little experience across the 8 different EU countries of children with intellectual and psychosocial disabilities participating in the justice system. The situation is even worse if we look at children that use alternative and augmentative communication. And now getting to the more positive side of it. There you go. So just to show that actually there are some examples of things that that exist in some countries. I'll try to read out because I'm not sure how easily it's readable for members of the audience. But I capture a quote that actually came from Lithuania of a child with a psychosocial disability that participated in the justice system, and we'll share that. And I'm going to read out. We spoke with a psychologist, a psychiatrist. She communicated calmly. I liked everything with her. It was not easy to understand, but it was easy to talk. There were some questions that made me uncomfortable, but I answered those. So, and this is really to highlight one important procedural accommodation for children with intellectual and psychosocial disabilities, sometimes the involvement of third parties, special communication specialists, who can support justice professionals, whether judges, prosecutors, to conduct the questioning, and in a way that the questions are or can be adjusted and more appropriate to the child, depending on the type of disability, and also their age themselves. Of course, already mentioned, the information can and should be available in easy-to-read formats and avoid illegal jargon. Another important procedural accommodation, which a lot of professionals already do, that which help children feel safe, is making sure during the questioning they have by their side a person they trust. It can be a person, but also can be an animal as well. Here, I was thinking, especially for Victim Support Europe, they have an amazing initiative which they call Fido, which Aleksandra can mention and talk about it way more than I do. Which dogs can accompany and be with a child and give them some sort of emotional support. And of course, as Leonor and Lucia mentioned, I think a lot of times hearings can be quite stressful. I know there's a lot of time pressures, but it's important to acknowledge that to adjust hearings so that to meet the timing and communication style of the child themselves. So they need to speak slowly, and the need for the communication itself to be slow rather than fast. And again, highlights the importance of individual assessment and understand the child before conducting the hearings. And I hope this helps already. Not a coffee break yet, but I hand over back to Aleksandra.
Thank you, Bruno, for this important overview of challenges and some good practices at the international level. Just speaking of facility dogs, just to tell you that we have in the room Jérôme from France, and they have a dog that works in his association. So during the break, you can ask questions about how it works in practice. And you can also ask me about how it works in practice, and I can then talk until tonight. But thank you very much for this. I think this brought us to the end of this first round of discussion. So I would now give the opportunity to our speakers who were involved in their national research to maybe just take us a little bit into the findings at the national level, and what were the kind of the biggest discoveries maybe for yourselves, but also what are the opportunities and what are the practices that you found. So like, again, is there a light at the end of the tunnel? So maybe let's start with Ugne this time, Lithuania.
Okay, thank you. Could you please bring back the slide that I had? I am very grateful to Bruno for somehow managing to identify something positive in Lithuanian studies results. I really appreciate that, and I agree, of course, that there were some positive practices that we identified, but not many, unfortunately. So in Lithuania, we conducted 12 semi-structured interviews with victims of crime who are children with disabilities. We interviewed children with intellectual disabilities, but also one child with a psychosocial disability. We interviewed their carers and various professionals in both the criminal justice system and support services. And we also conducted one focus group with court psychologists who play quite a big role in Lithuania when it comes to victims of crime who are children in general and including children with disabilities. So yes, the findings unfortunately mostly identify barriers that children with disabilities face in our country. First of all, unfortunately, the EU directive, Victims' Rights Directive, is not fully transposed in Lithuania yet in the legal system, so that in itself creates a massive barrier because there's no systemic guidelines, there's no requirements for certain things, including the individual needs assessment. So it's very much dependent on individual professionals, their skills, their involvement, level of involvement, and these are mostly these assessments or identifying of individual needs is mostly left to the court psychologists, to their discretion and to their professional judgment. But then again, like I mentioned before, this information, even when the needs are identified, doesn't necessarily follow the child when they face different professionals or different parts of the process. So this is a big barrier. Then, of course, this leads to a rare use of procedural accommodations in general. There's a big absence of accessible communication formats, like I mentioned before, including easy to read or AAC. Then there's also kind of leading, because of this, there's in general very limited direct communication with child victims and children with disabilities. Usually children are not addressed directly by the professionals in the criminal justice system. They instead communicate with the parents or the legal guardians, and all information is shared with them instead of children directly. And then, of course, that increases the or rather decreases any opportunities for meaningful participation of children in the proceedings. There's a lack of opportunity for children to ask questions. We found that a lot of the time, even though the state guarantees legal aid and a child will always have an attorney, but they might meet them for the very first time already in court, and then there's no, again, very little or no direct communication between the child and the legal aid representative or attorney, and that just leads to them being almost completely excluded from any type of meaningful participation. Lack of specialized training among various professionals, of course, was identified as well. And I'm talking about law enforcement, judges, prosecutors, state-guaranteed legal aid services. Not only children in general and skills that you might need to work with children in general is missing, but of course the disability-specific knowledge is almost completely absent. Training that might address this is inconsistent and of course not mandatory, so most of professionals know very little, if anything, about disability and individual needs that these children might have, and the barriers they face, and how those should be or could be removed. All this also ties in with the general stigma in Lithuania, stigma concerning mental health conditions, disabilities, but also stigma of being a victim of crime and going through the criminal justice system, being a victim or a witness. And we know that in general the victim blaming attitudes are quite prevalent, but also, when it's a person with a disability and you combine all these stigmas into one, it becomes really, really difficult and creates many barriers. Like, for example, assumptions that children with disabilities are somehow unreliable witnesses, prejudice and misunderstanding, which undermines their credibility in the whole process. And then, of course, no adaptations or procedural accommodations are put into place to help them participate more effectively and be heard and access justice. And like I mentioned before, the intersectoral collaboration is very weak. The case management system and information sharing is uncoordinated. There's very little that kind of is shared among different institutions, which could, in theory, address some of the barriers if it was different. And we identified some systemic gaps as well, which already I have mentioned some of them, but in general there is a lack of specialized personnel and child-friendly infrastructure, accessible infrastructure, informational barriers, as well as legal, like I said, legal obligations are not necessarily there to provide accommodations. So yes, the picture is quite bleak. Maybe I'll stop there. Oh, in my slide there's a QR code if anyone's interested to read the full Lithuanian report. We managed to publish it in the International Journal of Children's Rights recently. So you can scan the code and read more of what I've just tried to summarize. So I'll stop there. Thank you.
Thank you, Ugne. I'm not sure I heard that good practice that Bruno discovered.
No, sorry. Like I said, at least it was mentioned by Bruno, but yes, not in my presentation, unfortunately.
Thank you. So yeah, I mean, I think what Ugne described will probably be repeated several times in different national contexts, and I see that Portuguese colleagues are nodding. I would give an opportunity actually to Anna, not to exclude her. So Anna, can you maybe tell us about whether there's anything different in Slovenia regarding the findings?
Sorry, it always takes some time to unmute.
It's fine.
I think the technicians need to do it for me. But hope you can hear me now. Maybe on our side, I can first start with some good practice. But actually, the barriers are quite similar in Slovenia to what Ugne said, but maybe just to give some positive note. So from our research and our recent conversations, actually, that were kind of complementing the national briefing paper, we learned that, as I mentioned before, we have the Victim Support Office currently only in Ljubljana, but the ministry is now actually looking into options to establish it also in Maribor and Celje and other district courts. So that's one positive note, because a more thorough individual assessment in Slovenia is actually done by those offices, which are part of a court. So that's a good practice. Then also recently we started noticing that the Center for Judicial Training started to organize more training on the topic of children with disabilities in court proceedings. And actually the registrations are always full, which is also in a way a barrier because not everyone who wants to attend can attend those trainings. We just noticed there's one coming up this Thursday and Friday, and we noticed that it's already full, and we got some information that, for example, other experts, so not judges, but other experts working in the court cannot attend because it's so full. So there is a training, which is good, but it's not available to everyone, like the experts working in the court, for example, because the capacities are full. But we can see that people are actually interested in listening to those topics. So that was another good practice, and maybe the third potential good practice that we noticed, for example, in civil court proceedings, we have this intermediary person who helps children navigate through the process and helps the child express their opinion, for example, in divorce cases and so. And we think, and also recommended in the paper, that perhaps this institute could be also used in criminal cases. This person, kind of like an intermediary, is a pedagogist. I don't know what's the word in English. Like there's either social workers or teachers to children, so they're very skilled and actually know the child quite well usually, and they kind of function as an intermediary in civil court proceedings, and a similar institute could be used in criminal court proceedings. But of course, in order to do so, we need to ensure enough finances and a good structure to do so. So yeah, these are maybe some highlights. But now if I go back to some barriers that we saw in our research also, and that are maybe a bit different from Ugnes, is that we noticed that individual assessment, if it's conducted, it's usually conducted for victims of domestic violence or intimate partnership relations. But sometimes we're lacking them being conducted, for example, for human trafficking and other crimes. Also because the police, the form that the police uses, at least to me, seems to be a bit more relevant for victims of domestic violence than for victims of other crimes, such as human trafficking. Because the victims don't score enough points and then they don't get proceeded further if they don't. So that's maybe one drawback, and another one that in our conversation with the criminal justice professionals, they didn't recognize how actually individual assessment of a victim would also benefit them, not only the victim. That actually individual assessment would benefit them to enable them to get to know the victim better, to pose better questions that are more suitable, and then get more appropriate and more precise answers. So this is something that we thought could be actually more beneficial, this way of thinking, because it's easier for them, it's easier for us to convince them that this is something that doesn't only benefit the victim, but also the officials. So maybe these are some barriers that we also see. Also that I mentioned before, the geography, it's always an issue if you're not somewhere close to a bigger city where there's more psychosocial support as well, or actually any pamphlets with information for victims and so. Maybe this is all for now, some good practice and some barriers that we see in Slovenia.
Thank you, Anna. Maybe just a follow-up question for you, because I know that recently Slovenia has opened the Barnahus. Have you looked into that, and could you tell us maybe a little bit about that? What did your research say about it, if anything? We have a good representative of Barnahus in the room if you're not able to tell us more.
Okay. Sorry, I just can't unmute on my own otherwise. Barnahus is great, actually, a great example. It was established, I think, by law in 2021 or 2022. It was COVID times, so now it's slowly starting to become more used in practice. It's really great, but on the other hand, we see that referrals to Barnahus only happen when a judge decides so, because it's a procedural thing. So it's not that just a victim can come and any victim can be interviewed there, but it's a discretion of a judge to decide, as much as we're informed, that the child will be interviewed in Barnahus. which is a barrier. And also a few years in, not all judges already either know about Barnahus or do they recognize the benefits of interviewing a child there. So this is also another point of discussion that we added. We recommended in our recommendations to use this institute more, to inform the judges more that this would also benefit them because they would get a better testimony and also the victim will be much less traumatized. But maybe the representative can also say something in that regard.
Yeah, thanks a lot, Anna. And yeah, you raised some really important points, especially in terms of also the randomness of access to support to victims. And this is another, usually when we talk about accessibility of services and accessibility of criminal proceedings, we talk about accessibility for persons with disabilities. But then there is the other aspect of accessibility, and that is that usually services are based in urban centers, and then in rural areas it's much more difficult for any victim to access a service because the service simply does not exist. And then once they exist, then they're not accessible either. So there's several layers of accessibility that we have to overcome. So I know that colleagues from APAV and FENACERCI work together on research and the national report. So I don't know if you want to split your discussion. So maybe Leonor first about barriers, and then Lucia, is that okay? And Lucia to talk about good practices.
Portanto, só aqui compasso de espera. O que eu quero trazer aqui, que nós ganhamos muito no nosso relatório, foi perceber que, lá está, a diretiva, como em muitos outros países, contribuiu para nós fazermos o nosso Estatuto de Vítima, que está consagrado na Lei 130, 2015. O que acontece é, como em muitos países, quando a criança chega ao sistema, não é feita a avaliação das necessidades da vítima, mas, como neste caso é uma criança com deficiência, automaticamente a vítima é determinada como uma vítima especialmente vulnerável. Porquê? Porque é uma criança, não porque tem deficiência, aqui em Portugal. Ou seja, automaticamente, quando uma criança entra no sistema de justiça, é determinada como uma vítima especialmente vulnerável. Mas aqui o fator que está a pôr este cuidado é o fator criança e não o fator deficiência. O que é que isto significa? Significa que nós estamos a tratar as crianças com deficiências e crianças sem deficiências no nosso sistema exatamente da mesma maneira. Não há aqui esta adaptação, não há aqui este cuidado acrescido por ser uma criança com deficiência. Isto, para mim, para nós, a PAV, FENACERCI, é uma das grandes barreiras, para não falar de muitas outras, que se calhar não vou falar de todas, senão a Lúcia fica também sem conseguir, porque infelizmente o que mais vimos foi barreiras. Acho que aqui a palavra-chave é a formação, a falta de formação, porque o que nós percebemos é que muitos profissionais, apesar de estarem bem intencionados, muitos deles até gostavam de saber mais, não conseguem e não têm como. Não têm como porque não sabem como fazê-lo. E um dos testemunhos que nós tivemos nas entrevistas, isto vindo principalmente da Polícia Judiciária, que é quem tem competência dos crimes sexuais em Portugal, muitas delas sabiam que aquela criança não comunicava através de uma maneira, como nós estamos a falar, através de palavras, teria que ter outros cuidados, mas como não há instrumentos, não há metodologias standard para fazer esta comunicação, isto engloba que o próprio profissional, por si, tenha que perder mais X horas de tempo para conseguir mais 10 outras metodologias diferentes para conseguir falar com aquela criança. Isto não é fazível, porque aquele profissional depois tem mais não sei quantos casos por trás. Portanto, o que acontece é que fica aquém da sensibilidade profissional e aquém do tempo que o profissional tem. Portanto, isto são muitas camadas que nós temos que ultrapassá-las e que o profissional acaba por não conseguir fazê-las. E acho que agora passo aqui para a Lúcia para falar das outras. E só um ponto, porque o que eu vejo e o que eu vi nas entrevistas é que há vontade. Há vontade para saber mais, há vontade para haver esta especialização e há vontade dos próprios profissionais de darem uma humanização um bocadinho maior àquela criança que está ali. Mas, de facto, eles estão um bocadinho sem saber como e sem saber onde direcionar, e o que acontece é que muitas vezes os casos caem. Lúcia, não sei se queres complementar alguma coisa.
Eu acho que já falaste de tudo, se calhar também aqui só reforçar que Portugal transpôs as normativas europeias e o 22, nós temos, agora falta é que isto se transforme em lei e que seja obrigatório, por exemplo, a presença de um advogado no início de um processo de vitimização. Ele pode ser requerido se aquela criança tiver a sorte de alguém que a informe, tu podes solicitar um advogado. Portanto, uma criança vítima pode, em Portugal, passar todo o processo sem um advogado. Portanto, isto é um aspecto importante. Há aspectos e há situações que já funcionam bem, e nós ouvimos também essas situações em que os serviços conseguem comunicar, consegue-se fazer o que é ideal fazer, mas porque houve boa vontade, curiosidade dos vários atores neste sistema complexo que atua quando há uma situação de vitimização. Portanto, o que falta, e realmente é uma barreira, é estas guidelines, estas diretrizes que também estão em Portugal, transpostas para Portugal, que estejam plasmadas na lei e que criem caminhos obrigatórios, porque isto é orientador para os profissionais e eles precisam deste caminho. Falando também de uma força, a força é isso, já há exemplos que nos dão evidências que é possível funcionar dessa maneira e que a criança pode ser protegida em todos os seus direitos. Acontece espontaneamente, mas isso prova que é possível. Penso que basicamente e reforçar também esta vontade da formação que nós vimos nas nossas mesas redondas, que as pessoas têm e os profissionais têm muita vontade de aprender, e isso é importante, e de saber mais e de comunicar, isso é importante.
Thank you so much for these wonderful insights. So it's really, you know, as we say, the trouble and the struggles and the barriers are shared. Maybe they get a different shape, but there is also some promising practices. One that I might add to what Bruno was already mentioning, and especially when we talk to legal professionals, I have an opportunity to often give training to judges and prosecutors. And one of the things that I can't recommend enough, which is within their power, but they just don't think of it themselves, so they need to be reminded, is just making child-friendly, accessible summaries of their decisions and documents. And this is something that's easily done. It doesn't require a massive amount of resources. Today there are so many AI tools, etc., that can help with that. So these are the sort of things that can be used to also make the criminal proceedings more accessible to children, and especially children with disabilities. But now just a quick final round, and we will be only a few minutes late then for the coffee break, which I think is an enormous success. Do we have questions?
I would like to share some.
Okay, go on, share, and then I have one final round of questions.
I think it's okay. Let me introduce myself first. I'm Svetlina. I'm coming from Bulgaria, and I've been the coordinator of Link project for Bulgaria. Really quickly, I would like to share what we found. It's pretty much what you've said, but I'll tell it in the words of how we find it. Our main finding was that there are no cases of children with disabilities that access the justice system. This is not surprising. We've asked the professionals in the face of a prosecutor, the children or the victims, and we've asked also the NGOs that support the victims. And the answer were leading to the same conclusion, but I will share it with you in their own words. So when we asked the prosecutor why there are no cases of children with disabilities that reached you, it was a lady, she said, well, because those children are at home and they're protected, they're with their parents, they cannot be victims of violence. And that's a prosecutor, that's a lady that has lots of criminal cases in Bulgaria, in the third largest city in Bulgaria. So when we asked the victim, how was your experience when you suffered the violence? She was sexually abused several times. She said, I didn't know that that's violence until I, by chance, met a really good lawyer, a lady, that she told me that this is wrong and this is actually a crime. I thought it's natural. I thought I deserve it in a way because I was with disability. So when we asked the supporting, the social worker that was working in an NGO supporting victims, why there are no cases of children that reach the criminal system, the judicial system, she said, well, first, in many cases, those people don't share, they don't talk. I mean, people with disabilities and children with disability, they don't talk, they don't share. They stay really segregated. And secondly, she said, the level of tolerance of violence of the Bulgarian society is really high. I mean, we see the violence, but we keep silent. We just say, this is not our job. I mean, the society, the members of the society. So it's really hostile for a victim to understand first that he or she is a victim of violence. Secondly, the environment is very hostile to those people, and they are even suppressed to say whatever. And third, the judicial system thinks that there are no problems with those people. They are safe, and that's all. On the positive side, two things. Venera will speak today at this symposium on our experience with children, but children are active and they want to contribute, and that's the good part. As if they are given the word and the tools, they could do miracles with the system. It's just that we don't give them enough time to express themselves. And the other thing is Bulgaria has done a lot of work to expose the work of the judicial system online with the use of technology. Not particularly for victims and for children with disabilities, but a lot has been done in general lines. And this is a good ground to build up. So we just have to connect the necessary tools for children with disability with the general, let's say, IT infrastructure that is within the judicial system. And good things and good examples could happen from there. Thanks.
Thanks, Vetilot, for this intervention, because it also kind of reminds us that research was conducted in more countries, as Bruno has already said, but it would have made for a very big panel. So this is why but thank you. It was really, really useful. So one last question to the panelists very briefly then. How can your organizations, what Sveti was saying, how can your respective organizations do something to change the situation? We are developing this amazing tool also as part of the LINK project, which will be subject to further discussion. So let's put that aside. But just in general, what are the resources, maybe some activities that your organization are already doing? Ugne?
Now I feel bad for not mentioning any good practice examples from Lithuania. So first I would like to say that we do have some good practices. No, I mean, it kind of answers to your question as well about our organization. We are an advocacy organization, so we work to kind of try and change things on the systemic level and from various different perspectives. And one of the things that we can and we do is, of course, push for legal guarantees and to make amendments to certain laws, to develop new and better policies. And I must say, as a good practice example from Lithuania, for example, the whole field of domestic violence as a crime is very well developed at the moment. The victim support services are more and more developed, and they do recognize the disability as as a relevant consideration for everyone to know about and to be trained on. So on the level of the law as well, this is quite well developed at the moment, especially when it comes to children, because there's a lot of algorithms that are in place whenever someone becomes aware of a child who's a victim or witness of domestic violence. Of course, the disability side, if a child has a disability, there's still all the barriers I mentioned before, but at least the legal side is a bit better. So we can push for legal guarantees and amendments. We also develop, as an organization, we develop and deliver trainings to professionals. And then, of course, raise awareness in general, which as an attempt to eliminate the stigma that I mentioned before concerning disability, concerning victimization, and having your child go through the criminal proceedings in general. So I think we're running out of time, so I'll stop there.
Thank you. Thanks a lot. Apav?
Portanto, uma das grandes conquistas que a APAV quer atingir é aqui a formação dos nossos técnicos e técnicas de apoio à vítima, e é um caminho que nós estamos a começar a percorrer agora. Ajudou e está a ajudar muito o projeto Link, porque nos está a mostrar qual é o caminho que temos que ir, e nós sabemos que o primeiro passo é ter instrumentos, seja tecnológicos, seja materiais, para ajudar nesta comunicação para crianças e pessoas com deficiência que utilizem uma comunicação alternativa aumentativa. Este é o primeiro passo que a APAV quer recorrer. Juntamente com isto, é importantíssimo tornarmos o nosso espaço acolhedor, com ambientes seguros, com pouco estímulo, para as crianças com deficiência conseguirem dar o seu depoimento, conseguirem falar e estarem seguras enquanto estão a fazê-lo. E como eu disse há pouco, estas adaptações podem ser muito fáceis e é um dos primeiros passos a acompanhar a comunicação. Depois disto, temos que garantir que esta formação, que as adaptações são contínuas ao longo do espaço e do tempo. Os técnicos de apoio à vítima têm de estar constantemente a par das novas atualizações e das novas formações que existem, como acontece com outras áreas de vitimação que a APAV tem o cuidado de dar essa formação. Isto traduz-se em ver a criança como alguém com direitos e não pô-la de lado, ou seja, traduz-se em humanizar aquela pessoa. E, obviamente, no processo de apoio à vítima, isto também é possível com acordos e protocolos entre várias instituições que nós, à APAV, estamos sempre abertos para conseguir estabelecer, entre eles, naturalmente, com a FENACERCI e com outras organizações de Portugal que são aqui fundamentais para o direito das pessoas com deficiência. Não sei se passo diretamente para a Lúcia, já que estamos aqui com os headphones.
Sim. Então eu pego na formação. A APAV, portanto, é uma federação que congrega várias organizações de apoio à pessoa com deficiência intelectual e já tem experiência de formação e também tem experiência de formação na área da justiça por projetos anteriores, como seja o Enable. E isto da formação é muito pertinente porque nós fizemos 7 grupos focais com agentes da justiça, da polícia, do apoio à vítima, da educação, etc, etc. Portanto, foram primeiro 6 grupos focais para informar o projeto, depois mais à frente tivemos necessidade de fazer mais um. E o que nós reparamos durante os grupos focais é a aprendizagem que houve entre entidades, entre áreas e entre serviços. E quase que isso nos deu esta informação de que é importante fazer formação, treino conjunto. Quer dizer, o treino tem que ser feito com multidisciplinaridade. Estarem todos presentes na mesma sala. Cada serviço tem o seu know-how, cada área tem vários serviços e, portanto, as pessoas têm que se conhecer, o que é que fazem, conhecer nem que seja os acrónimos, que já é uma tarefa homérica, conhecer os acrónimos de cada área, o que fazem, as suas fraquezas, as necessidades que têm, e depois perceber como é que todos juntos conseguem fazer um sistema que seja harmonioso e redondo, não é? Como é que se podem suportar. Portanto, eu penso que, e a FENACERSI tem esse papel, de formar, mas fazer, a partir deste projeto Link, penso que há este enlight, que é importante fazer formação conjunta entre profissionais e que esta formação, e também na conversa com a APAV dizer-nos nós não percebemos nada de ciência, e nós dissemos nós também não percebemos muito bem de leis, e portanto também há aqui uma literacia base que todos os sistemas devem ter em comum para haver uma comunicação, porque o propósito é comum. Afinal, estou a falar muito depressa. Portanto, estou a falar muito depressa. A formação, portanto, é um aspecto importante. Outro aspecto importante é a FENACERSI também se tem preocupado com a acessibilidade cognitiva e, portanto, já tem alguns instrumentos e tem, por exemplo, em resultado do projeto Enable, um guia para a acessibilidade para facilitar o acesso à justiça e, portanto, mais do que ter esse guia, é pôr esse guia a funcionar e em prática e nas mãos de quem dele precisa e, portanto, isso também pode ser feito através da formação. E também me esqueci de mencionar a formação como um sistema que transforma e não só informa, porque isso também é importante. Sabemos que um dia de formação e passar informação não tem impacto. Tem impacto se a formação tiver vários formatos e tiver formatos, além de passar informação, é uma informação que também provoca experiências e são essas experiências que transformam. Portanto, para que isto corra bem, é importante fazer uma formação que não seja boring, que seja uma formação que seja diversificada em metodologias e que seja continuada e atualizada, porque a formação nunca acaba. É um projeto infinito e temos que o assumir como um projeto infinito. Depois também a FENACERSI pertence a outra entidade, que é uma confederação de cooperativas, e isto para falar que é necessário, depois de um projeto como este, mudar práticas, mas chegar também às políticas, não é? Fazer lobby junto das políticas e nós percebemos que há aqui coisas que têm que mudar a nível legislativo e, portanto, a FENACERSI tem esse acesso, tem trabalho anterior nesta mudança de práticas. E depois, porque agrega várias associações com muitos jovens e muitas crianças, e estas organizações suportam também na comunidade, acho que é importantíssimo nós pensarmos também no que podemos fazer em relação ao apoio para além do crime e para além do processo de crime. Aquelas crianças, tem que ser prolongado o processo de apoio, para além do processo, tem que haver aqui, e isto nós aprendemos muito dos grupos que fizemos de jovens e que os ouvimos, eles têm muito a dizer, eles sentem como toda a gente e se lhes damos espaço, e um espaço que seja psicologicamente seguro, eles têm tanto a dizer e nós ficámos realmente, e eu trabalho com a deficiência há muitos anos, ficámos impressionados que perante um tema tão delicado, o feedback e as ideias que eles nos deram. Portanto, temos que lhe dar esse espaço e esse apoio para além do processo, este suporte mútuo, validar o que eles sentem e dar-lhes voz muito mais vezes. Eles nunca são os primeiros da sala a falar, nunca estão no palco e isso é algo que temos que estar sempre a pensar.
Thanks a lot, Lucia. We have also Anna online, just quickly, because we're running out of time.
Thank you. I think it's just important to underline what everyone said when it comes to connecting different institutions, organizations. We noticed that, of course, training, but also just exchange of views, and actually not everyone's aware of what competence of each institution are. So I think our major recommendation would be to, of course, organize trainings, but also to organize just meetings where people can come together and then talk about what their competences are, what issues they struggle with, how the system could be more interlinked. And that's it. Thank you.
Thanks a lot. That is actually a very, very important point to kind of keep multidisciplinarity, multi-agency work alive and coordinated. Last but not least, Bruno, Validity.
Thank you. I join everyone just highlighting how capacity building and training is important, and that's something that certainly Validity can offer, and we have offers so far. Just giving different trainings for prosecutors, police, judges on how to adjust proceedings depending on the type of and disability. And also another important thing, because I understand all countries have different political support, let's say, when it comes to reform. So we're also very willing to, whenever there's zero political support and rights of victims continue to be violated, we're very happy also to take cases and support strategic litigation on their behalf, alongside Victim Support Europe as well.
Thank you very much, Bruno. So maybe one quick question from the audience, if there's any, but I would also like people to have their coffee break. Okay, I think everyone's motivated by the coffee break. Thanks to my wonderful panelists. 15 minutes, I guess.
Yes. Let's take a 15 minutes break. So we'll come back at 11:15. That's Portuguese time. For those online, 12:15 Central European time. Thank you.